May it please the Court. Kenneth Monroe for Plaintiff Appellant George Tucker. This case concerns the prison's violation of Mr. Tucker's religious liberty and the prison's attempt to insulate that violation from judicial review. For 15 years of administrative proceedings and nearly 8 years of litigation, Mr. Tucker has sought a simple religious accommodation. He seeks to congregate with fellow members of his religion, the nation of gods and earths, to freely discuss its teachings. His claim under
Your client didn't get that?
He has not gotten that.
What has he gotten?
He has been told that he may restart an administrative process that he's been trying to complete for over a decade. And he has been told that the outcome of that proceeding would be dependent on the prison's view of security and time and space. In other words, it said, you may request it, but it's basically begged the question about whether it will provide time, space for nation congregation, which is exactly what he's seeking. To prove that the district court lacked—
Isn't that the same process that every other group has to follow?
It is, but once we're in litigation, it is the state's burden to prove that it has lifted all substantial burdens on Mr. Tucker's religious liberty. And so to moot the claim, it has to show that it has removed those substantial burdens. So this is not like an equal protection claim where Mr. Tucker is just seeking some kind of equal treatment. He is seeking something very practical here. He wants to actually meet and get in a room together with his fellow believers to freely discuss his religion's teachings, and he's still unable to do that. He's in the same position he was 15 years ago when in 2007 he was attending Muslim services and requested to be able to attend separate nation congregation, and the Religious Practices Committee said no. So he's in the same position where he was when he started this entire process.
How many, does the record show how many people there are in his prison unit that are subscribers to his faith?
Yes, it does. I believe there are at least 6, and they're enough for there to be a sufficient number to actually congregate.
So there's 6, and some of the other groups, there's 10 other groups that are allowed to congregate?
That's correct. So
how big are they? I mean, some of them are obviously huge.
Sure, yeah, so for, you're correct, Your Honor. For Muslim services, for example, there are thousands of prisoners that are Sunni or Shia Muslims. Mr. Tucker is not a Shia or Sunni Muslim, which is the only services available for in these generic, umbrella group religions is generic teaching. So you might have Christianity, but if you're a Catholic or if you're a Baptist, you might not have those. And he's seeking something that's specific to his religion. The district court erred in concluding that it lacked jurisdiction, and it was the state's burden to prove that the district court lacked jurisdiction, and it really had 3 burdens here, and it met none of them. And this court could reverse on grounds of any one of these failures. First, the state failed to prove that it allows Mr. Tucker to attend separate nation congregation. As I discussed, his request remains denied. The state has irrelevantly shifted him to, or the nation umbrella group, to Muslim, which is where he was when this started, which allows him to attend generic services. And although he may request separate nation congregation, the outcome of that request remains subject to the state's security conclusion about the nation, that it and he are violent racial supremacists who threaten prison security. In other words, the state has consistently said no to Mr. Tucker. And at best, the state now maybe says maybe, subject to security concerns, it refuses to repudiate. And that is not enough to meet the state's burden to—
Isn't everyone else subject to security concerns?
That's correct, Your Honor. But under RLUIPA, it is the state's burden to either allow him to congregate and say that you're not a security threat and we can let you practice your beliefs without any kind of substantial burdens on that exercise. So it's important to know whether he can actually attend it, whether they'll actually approve the request. And I think that, Your Honor brings up a good point, because on appeal, the state has entirely changed its theory of mootness about this case. Below, there is approximately 3 sentences of argument from the state about why this case is moot. It says, Mr. Tucker is allowed to congregate, full stop. Not separate nation congregation, just any type of congregation. Of course, he started this whole process because Muslim services were not sufficient. And then, and it's really like 3 sentences. I would encourage Your Honors to look at that brief. And then on appeal, the state entirely changes course and advances a new theory of mootness. And it's based on essentially two arguments, that Mr. Tucker all along only sought equal treatment and that he only sought the removal of some kind of categorical ban. But of course, that's not what RLUIPA contemplates. RLUIPA contemplates that if your religion or your religious exercise is substantially burdened, then the state has the burden to show that it has removed all substantial burdens on your religious exercise. And the state has just simply not done here. And I actually think it's important to look at how this claim has been framed throughout this litigation. So following the Spears hearing, which is a hearing that affords pro se litigants like Mr. Tucker to develop exactly what it is they're seeking in dialogue with the magistrate, he said, "I would like to be given time and space to facilitate a class and function for ourselves outside of the traditional Islamic scope, away from those individuals." That's his quote. And that's what the district court realized. Tucker said after the Spears hearing and the report and recommendation, merely a week after that, Tucker is seeking to be allowed to congregate with other adherents of the Notion of Gods and Earth's faith group, separate and apart from the other Muslim inmates, such as the Sunni practitioners. And I could go through the entire history of this litigation, explaining exactly why what he's always sought is just this very simple religious accommodation, to meet with other adherents.
And we're talking, from what you say, this group that he wants to get together separately, 6 people, right? Is that what the record shows? It's just he's arguing for himself and 5 others?
So there, in his particular unit, which is the Caulfield unit, there are at least 6. And their grievances are included in the record and were attached to the complaint as well. They're all seeking this. But in the entire Texas Department of Criminal Justice, the entire prison system, there are at least 40. And I think that that's spelled out even in the state's brief. So there is no issue here about whether Mr. Tucker has a sufficient number of fellow congregants. I also want to talk about the voluntary cessation doctrine, because even if the state had proven that it allows separate non-nation congregation, and the affidavits support, the actual evidence supported or submitted in support of that notion doesn't say that whatsoever. There's an elliptical, logical jump between what the affidavits say and what the state's brief says they say. And of course, we have to look at the affidavits, especially here where the procedural posture is on a motion for summary judgment based on mootness, and you cannot insert words that do not exist there, certainly under the summary judgment standard. In fact, any evidence must be construed in the light most favorable to Mr. Tucker as the non-movement. And in those affidavits, it says he may request separate nation congregation. And the affidavits are actually internally inconsistent. It says he may also request separate nation congregation, and then it says he may seek it, and then there's a gloss in a later one that says he's allowed to seek it subject to security concerns and time and space, which is of course what he's requesting. So there's no statement that he's allowed to attend it, and there's no changed view of Mr. Tucker or the nation at all. The only evidence in the summary judgment record is the state's 8-month-long conclusion research project and its conclusion that Mr. Tucker and the nation are violent racial supremacists. It spent over 300 pages cataloging its findings. Now that the state, in its briefs, purports to change course, there is nothing about Mr. Tucker, his beliefs, why his belief that the black man is God is not racial supremacist, or why it does not threaten prison security, or why they think that they all of a sudden can accommodate that belief without threatening prison security. So it's undisputed in the summary judgment record that the nation is viewed as a security threat.
So to summarize, I take it your theory is your client went from being categorically excluded to being subject to the standard procedure, and your point is being subject to standard procedure isn't relief. It's the actual getting to congregate only that would be a victory and therefore not a moot case.
That's exactly correct, Your Honor. I also would like to build upon that point and discuss the timeline here, because I think that that's something that could get lost in the briefs. Mr. Tucker, all of the grievances that give rise to this case were submitted before the state impose what the state calls its categorical ban. So he filed suit in July of 2014, and the state denied Mr. Baker, who was a fellow nation adherence request, a month before that. But all the grievances that give rise to this were in late 2013 and early 2014, and Mr. Tucker didn't even know that there was a racial supremacy type, conclusion writ large at the time that he filed his lawsuit. And this is clear in the Spears hearing transcript, where he thinks that Mr. Baker, whose denial forms the basis of Mr. Tucker's then denial, was a nation adherent. He thought he was a member of the Moorish Science Temple, which is a different religion. The only time that the idea of racial supremacy as a grounds for denying Mr. Tucker's accommodation comes in the state's motion for summary judgment on the merits in 2015, and that is only a couple, I think 3 or 4 weeks after Mr. Tucker receives the denial of his accommodation on the basis of race. So when he was starting this, he was trying to meet with other members of his faith, wasn't allowed to, and the nation's, the Religious Practices Committee's research into the nation was ongoing, and so they denied requests on the basis that we're looking into this. So the notion that he saw a categorical ban struck him down in some abstract sense, and that was the basis of his claim. It just isn't supported by the summary judgment record here.
Well, in any event, that goes to the merits, right? It doesn't go to whether the case is moot or not.
That's correct, and I think that
in other words, if you're wrong about that and the state's right, that means the state should win on the merits. It doesn't mean that the case is moot at this stage.
Do you mind clarifying if what they're right about?
Well, let's just stipulate that there are serious security concerns.
Yes.
And the state has a point on that. Mm-hmm. That doesn't make the case moot. It just means that the case should be judgment for on the merits. I'm not forecasting that. I'm just trying to understand where these arguments go.
Your Honor is exactly correct. The question under RLUIPA is, when he's not allowed to do this thing that he wants to do, attend separate nation congregation, then the burden under RLUIPA shifts to the state to prove that it is using the least restrictive means of advancing any compelling government interests. And the state can't get out from underneath that burden by saying, you can request the thing. It has to say you're allowed to do the thing, and it has to show that it's using the least restrictive means of doing that. So the first time we were at this court, the state argued that Mr. Tucker attending Muslim services had been a least restrictive means. So that was a merits argument that the state made. Now on appeal again, Mr. Tucker is allowed to attend generic Muslim services, but not separate nation congregation. And the idea that Mr. Tucker, that is the least restrictive means is a merits question. And fundamentally, Mr. Tucker brought this case because Muslim services are insufficient. So if the district court wanted to grant relief, it could have done, after adjudicating the merits, it could have done what the state of Texas's neighboring state of Oklahoma did in the case Siempa v. Jones. So in that case, there was a violation of RLUIPA in a nation congregation request under RLUIPA. It's an identical claim as to the one here, at least in terms of seeking separate nation congregation. And the district court ordered the state of Oklahoma to submit a detailed plan for accommodating separate nation congregation. So in other words, you have to show the details of what it is that you're proposing to do for Mr. Tucker or for Mr. Siempa in the analogous case. And there, the state submitted a plan. It said, we'll allow Mr. Siempa to meet for several hours every month, and he can meet on Tuesdays, and the least restrictive mean that it imposed there was, well, we're going to create a report about what was said during the meeting so that we can monitor and make sure that nothing's going on. And that as far as restrictions go, that's a fairly reasonable one. The state here is trying to just pretend it's not in court by just saying, we'll request it again, we'll see what happens. And that's just not allowed under this court's precedents. And I also want to get to the voluntary cessation doctrine. I think that we clearly win on the first prong, which is whether they've actually done what Mr. Tucker seeks through his claim. But if this court disagrees, it is well-settled precedent under this court's precedents. You can look at page 12 of our reply brief. There are 15 cases concluding that the test for voluntary cessation is the same for private and government entities.
Your point is the government hasn't ceased.
It hasn't ceased in the first place, and the state doesn't even argue that it gets deference on that point. And even if the state has ceased, this court's precedents are clear that the state is subject to the same burden as private defendants. I see that my time is up.
All right. Thank you, counsel.
Thank you.
Cherry,
Yes,
you may proceed.
thank you. May it please the court. The department ended its categorical ban on nation religious practices almost 3 years ago, granting Tucker his requested relief and mooting the case. Under this circuit's law, the department is accorded a presumption of good faith that that policy change was sincere and not a litigation tactic to be abandoned after the litigation ends.
Wait a minute.
Yeah.
I thought he wanted to get together with the 6 or so that are in his unit, and separate congregate. So
Uh,
the state told him, go for it, do it?
Yes, Your Honor. So,
How did we
well,
get here?
To be
Why
clear,
are we here?
To be clear, Your Honor, there was a categorical ban. The case went before this court. The court had grave concerns about the reasoning behind the ban. So when we went back, we changed the policy and we got rid of the categorical ban and we put the nation in the same group with all of the other religious groups that are entitled to what we would call secondary services. So first, Mr. Tucker's entitled to the primary services under the kind of Muslim umbrella group. And so he can have their religious holidays, et cetera. But also for the nation, under the secondary services, he's entitled to request secondary services. And so he's entitled to request congregation, he's entitled to request nation material, he's entitled to request a holiday and perhaps a lie-in for that holiday. But all of those requests are subject to the same constraints, which is time, resource, security concerns. And that setup, which is called the Scott Plan, was already affirmed by this court in Brown v. Collier in 2019 and reaffirmed in subsequent cases. And so that's where Mr. Tucker is now. He has the relief he wanted, which is to be treated equally with other religions. And I know that Mr. Tucker argued before. Oh, yes.
Is plaintiff's theory that they just wanted to have the administrative procedure that everybody else gets, or that they wanted to congregate?
So we would say that what he asked for was equal treatment with similarly situated religions. And I can point you to places in the record where he asked.
Yeah, please do, because I confess I've not studied the complaint as carefully as I should have.
Sure. So,
What I'm hearing basically is two very different theories of the complaint. You're saying, I just want to be subject to the same procedure as everybody else. And if that's true, I think the state has a point. I hear opposing counsel saying, I don't care about the procedure, I want to congregate.
yes.
And if that's true, then it seems to me there are two obstacles to their ability to congregate. One is surviving the procedure, and two is being eligible for the procedure and not subject to a categorical ban. And the state's removed the second, but hasn't removed the first.
Right, and so actually you can just look at the plaintiff's brief from 2016, I think on page 16. I'm sorry, from 2018 on page 16. You can also look at the record in the brief, you can look at 2386. You can look at the record of appeal, pages 33, 39, 58, 60, 66. And you can also see, just as the court below understood it, so in the magistrate judge's report and recommendation at 2060, they say Tucker is seeking to be allowed to congregate with other adherents of the Nogi or Nation faith group, separate and apart from the other Muslim inmates, such as Sunni practitioners. And then I'm going to just do an ellipsis, the full and equal opportunities to participate in without discrimination and then religious services. But in the 2018 brief at page 16, the quote is, Mr. Tucker repeatedly filed broad requests for the state to treat the nation on equal terms with other religions.
So in theory, they could file a lawsuit in the future saying, I want to actually congregate, not just the same procedure, and we could have that litigation. Your point is that is not this lawsuit.
Yes, Your Honor. And we're not saying, we've tricked you, come back and ask for the more specific thing.
No, but they have to draft their complaint the way they want to present it.
Right. But what he is eligible to do is put in this request. Biggest impediment that we've come into right now is just the lack of a volunteer to lead the nation congregation. So even if the nation group is only 6 people, we'll still allow them to congregate and have holy days. Right now we're just, and you can see in the record at 2147, right now we're just trying to find a person who is a
The
nation
separate
adherent.
congregation issue
Yes.
is tied into the lack of, the state's been helping, trying to find an independent person to meet with that. So that has to, according to what I would call the rules of engagement here, that separate outside person has to be a part of their separate congregation
Yes, Your Honor.
from the beginning.
Yes, Your Honor. And that requirement for the volunteer has also been upheld by this court. You can start with Brown v. Collier in 2019, but also in Adkins, which is a case cited by the appellant. The reasoning here is that there were some safety and security concerns. I don't want to get into it. I don't think the details are in the record, but what the courts have held basically is that our need for volunteers and the lack of volunteers is not a violation of RLUIPA, because it's the lack of volunteers is not our fault. It's just kind of the situation.
Does a volunteer have to be an inmate?
No, Your Honor. The volunteer is someone who is outside of the prison. So it could be a chaplain. It could be pretty much anyone who has some kind of trustworthy identification that they understand the religion and that they are willing to participate and kind of keep an eye on these services. So we had...
And that's the person who reports to the prison?
Right. So they don't have to go through the full TDCJ training or anything like that, but we do give them a brief security briefing, and we just want them to be there to make sure that the inmates are actually doing whatever religious service there is, that there's no kind of internal issues. The alternative would be to have kind of the inmates lead the services themselves, and then you have a leader, which has caused problems. You have kind of this unsupervised time, which has caused problems. And the larger issue and why the volunteers are important is because there are, I think, over 60 religions at Cofield Unit alone. And so just in terms of kind of staff availability to be there at all of these congregations for all of these religions, we just can't do it. We don't have the resources to do it. And so that's why we developed the SCOT plan, and that's why when presented to this court affirmed that SCOT plan satisfied RLUIPA. But to get back to your question, Mr. Tucker has suggested some individuals. We also did research and looked for some individuals. I think we did Brooklyn, Dallas, Houston. We just, even before we would do any kind of security or check or anything like that, they just couldn't travel to make it here. So if there are no further questions on that part, I'll just move on a bit. So another thing that, another reason I would guess that Tucker claims the case is not moot is because he thinks he's entitled to additional accommodations. So he mentions certain items that he had requested that he wanted, or I think he also mentions some religious holidays that he claims that he requested. And he also says, this court can grant a declaratory judgment or an injunction, but none of those pass the hurdles of the PLRA's exhaustion requirement, the Declaratory Judgment Act, and then Article 3's general limitation on this court's jurisdiction, which requires it to only address live cases and controversies. With regard to the other accommodations, the district court dismissed them with prejudice for lack of exhaustion under the PLRA, and this court affirmed that finding in its 2018 decision. So they're no longer in the case. So he can't bring them up now to say that his relief hasn't been granted. He also, with respect to his demand for declaratory relief, Declaratory Judgment Act requires that also to, you can issue declaratory relief in the absence of a case or controversy. Article 3 also prevents courts from issuing injunctions because injunctions are also something that you can issue if the case is moot. And then I think that Tucker, or opposing counsel, raised this toward the end, which was he argued that he was entitled to summary judgment at this point. We also disagree with that, first because of the mootness point, but also because when this case went before the court in 2018, the court held that there were material issues of fact that still needed to be decided. Really nothing has changed since then, so the request to just skip ahead and do summary judgment when the court didn't do that before contradicts this court's holding. In addition, this court is a court of review, not first view, and the district court did not decide the merits because the district court correctly found that the case was moot. So in sum, the department's policy change in 2019 moots this case. This court should affirm the district court's judgment.
So what you're telling us is, contrary to what they apparently believe, with good lawyers,
Yes.
they've actually won this case, and so they just need to be piped down and go away. That's your pitch, right? Am I right?
We wouldn't say it exactly like that. We would say that, as the record reflects, Tucker has put us to the test with his request for a holy day. Other inmates have put us to the test, and you can see the results at 1564 and 1565 when we've granted those requests. You can also say, so in terms of the relief that he's requesting, he has been granted that. In terms of his concern that he would have to go through the administrative process, he didn't ask for preference above other religions, he asked for equal treatment. And all religious adherents who want secondary services put in these requests. And partially that's so that we know what they are, right? And we can address them because they all go before the RPC. And I think that another concern that he had was that we would use the security factor as a way to kind of sneak in our categorical ban. One that's not the case. It wouldn't make sense given the fact that we have accommodated some of the requests since our policy change.
Well, let me ask.
Oh, sure.
So have they actually been allowed to congregate separately the way they want?
No, Your Honor. And
Well, so that's what the case is. I mean, that's a major issue here, isn't it? What am I missing?
So that would be an issue, except for the fact that what they have are all the rights that other religions have under the Scott Plan. So other religions also are not allowed to congregate for secondary services unless they have a volunteer. So the issue...
You agree he could sue and say, I deserve under our LUPA the right to congregate. Not the right to the same procedure, not to the right to a particular process. I want to congregate, and until I get to congregate, our LUPA rights are being violated. I think your point is that's not this suit.
Yes, it's not this suit. He could sue. He wouldn't win because...
He'd lose on the merits, you're saying.
He would lose on the merits, but he could bring that suit.
But we would get to the merits in that case.
It's just not what he asked for here. And so we're not saying kind of he will never be able to congregate. If he can suggest other volunteers for us to reach out to, like we did before, we'll follow up on that. But...
So I just want to make sure I understand, because he has to ask for, I guess, he has to make a request and be permitted. I don't know if he gets some written permit, but he has to make a request, and then permission has to be granted.
Right, it's I-60 process to the RPC.
But that permission is subject to an approved volunteer. They got to have that. Then they got to have, and then there's some time and venue and security concerns that have to be addressed with each one of these requests.
Not necessarily. It depends on the request. So for whenever the adherent wants to congregate in a group, then we need a volunteer to be there. But if he said that on February 22nd, the holy day, he wanted a lie-in where they just wanted to not have to do work or participate, that he doesn't need a volunteer for, so he could request that. Also, if there are particular nation paraphernalia, like the flag or so on.
Let's go back to congregate, though.
Oh, sure.
They want to congregate. Tell me what they have to do now.
So to congregate, they'll put in their request through the I-60 form. That'll go through to the RPC. We will, if we, and to be honest, I'm not sure if we would kind of resuscitate our search or if we would just say there's still no volunteer.
So you're
If
saying
Mr.
the
Tucker-
only thing standing between them and being able to congregate right now is a volunteer?
I'm not going to go that far, Your Honor. So obviously there's the time and space issues.
Okay, that's what I was
So,
raising. But
just in terms of, is there, and here we're not treating any religions differently. It's basically just, is there a place for them to meet? Given kind of our resources and the number of other religions that want to meet.
their concern seems to be, because I think you agree with me, we got more than a volunteer that you consider when you're deciding whether or not to allow them to congregate.
Yes, Your Honor.
Volunteer is one of the things, but I mean, the time is something you consider, I guess.
Right.
And you may be saying, doesn't matter to us what time, but the time is one, and then the space, where it's going to be,
Yes, Your Honor.
and then security.
Right, Your Honor.
And what I thought I heard them saying was, given this voluminous report you have about all the security concerns, they expect that you're just going to fall right back on it's a security concern, and then they won't be allowed to congregate.
Yes, Your Honor. So,
But what I'm hearing you say, that's why I want to, but what I'm hearing you say is, only real problem now is a volunteer. All these other things, no big deal.
no, I didn't mean to make that representation.
All right.
So they are required, these other factors will come into play. Generally, and this is not in the record because it really wasn't raised below, but if it's a security thing, it's if there's a head count that's off, and so everyone needs to go back to their cells, or if there's a riot or something, it's that kind of security concern. Obviously, it's not the categorical ban because other religious accommodations have been accepted or allowed, right? Another thing I think, another thing that's, I guess, at a issue here is, I'm sorry, I feel like I lost the thread of the first part of your question,
You
and I'm
can
trying to
go
find
ahead with
it
your
again,
argument.
but.
You've answered my question.
Okay, all right. But yes, so here I think also, first there's just speculation, right? Like there is no evidence in the record that we have used this security example as a means of rejecting any of the requests post our policy adoption in 2019. You can also look at cases like New York State Rifle and Pistol Association, where the per curiam Supreme Court said, obviously New York City and the state changed their policy because they didn't want the issue to go before the court. Well, that was obvious to us, that was obvious to Justice Alito, but it's a change, and now we just look at the policy going forward. So it's not always that, while things like a weak justification, or you make a statement like an Adiron construction company where one government entity says there's been a change and one government entity says there's not a change, those are indicia that the policy change isn't legitimate. There are no indicia like that here. And then under this court's law in Sosamon, the government is given a presumption of good faith that our policy change is that we are not going to revert back to the old policy. And it was Tucker's obligation to rebut that presumption, and he failed to do so.
So right now, to where we are today, they've got put in a request to have a separate congregation, I guess a meeting, not sure, but a meeting, in the unit that has 6 people, 6 of their adherents. And your answer is no, because we don't have a volunteer. That's it. It comes down to that. I don't know whether there are many issues, but that's the big issue. We don't have a volunteer for a meeting of 6 adherents in, what is it, the Cofield unit, or I've forgotten which is the key unit here.
Yes, it's the Cofield unit.
That's it?
So again, I don't want to misrepresent and say that the other factors might not play a role later or as part of it. Right now, our biggest concern is just helping them get a volunteer, partially, I think, because these other concerns, like, there's no categorical ban concern in the security part, we would try to accommodate them for time and space. So all we need to do is kind of make sure that there's some supervision there. That there's some
where
person.
the volunteer comes in.
Yes, that's where the volunteer comes in. And this plan, the Scott plan, which was approved by this court, part of the reasoning was just a resources issue, right? That, we'll provide the staff for kind of the umbrella religions, but with all of these other religions, which go from kind of vampirism to witchery or something like that, that we just can't provide the staff for all of them. And so, and we do need someone there. So that's kind of the process that we have everyone go through. And also under AD 0730, part of our process is to help try to find volunteers. And so that's what we would do. If we got more information or we could do more research, that's part of our process. If there are no further questions.
Thank you, Counsel. Rebuttal?
Thank you, Your Honors. The state doubles down on a theory that is unsupported by the record. The state, I'm sure, would love for us to pipe down and go away. But we're in court, and the state has to prove that it allows the accommodation that Mr. Tucker seeks. And it's important to remember this is a claim under RLUIPA. The way that RLUIPA works, if there is a generally applicable rule or regulation, this is in the statute of RLUIPA, and it imposes a substantial burden on the person that wants to exercise their beliefs.
Well, let's say, because what I heard the state say is they're scouring the landscape to find a volunteer. So your time, their time could have been better spent today scouring the landscape for a volunteer instead of arguing this case. So is it your view that even if there was a volunteer, your people wouldn't be allowed to meet?
The volunteer issue has never been an issue in this case. This is something that has been concocted in a reply brief on the motion to dismiss below. It has never been a part of this case. Mr. Tucker is not challenging a volunteer requirement. He is challenging the refusal to let him to congregate. And so
what they're saying is you can, as soon as you get a volunteer.
I think respectfully, Your Honor, I think that counsel was asked that several times, and she refused to say that it was just the volunteer. She said, I think her words were that they are not. We would try maybe with space and time, but he's seeking space and time, and they haven't said that they will allow. The request remains subject to time and space. I think it's actually worth.
Well, and I guess that takes me to, but that's the same as everyone else. Everyone else is subject to those same conditions.
That's correct.
And what I heard the state say is, and that's what you ask for, really, is to be treated the same as everyone else.
Yes, that is
equal treatment.
You're correct, Your Honor, that's what the state's saying. That's just simply not what this case is about, and the record shows that. So I could go back.
Help us where I'm not saying it's not in there. I'm just asking for help. Where is it in the complaint?
So the very first page of this docket, it's after the docket sheet, and it's ROA 24. It's a civil cover sheet for pro se litigants. I think this is worth emphasizing. He's pro se, so he is entitled to liberal construction of anything he's saying in his pro se pleadings. And he says, it asks, what would you like the court to do for you? Injunctive accommodation of the nation of gods and earths with provisions of scheduled time and venue for our assembly and practice, as well as declaratory judgment of his rights under RLUIPA. So, and this is straight through the entire case. In the R&R granting summary judgment on Mr. Tucker's RLUIPA claim.
The complaint, it's called the memorandum of law, but I take it this is the complaint at page 28. Is there anything in that document, or are you just relying on the cover sheet?
No, in the complaint, I think it's the last paragraph, he also seeks provisions of time and scheduled time and space for separate nation congregation. And by provisions, he just means I want to be provided with time and space.
Where are you said last page, so 50,
That's correct,
50 of the record?
I can see if I have the site here.
I'm not trying to slow you down.
But he's seeking...
You're saying it's on the last page?
Yeah, he's seeking 6 things, and then there are 2 that are related to congregation. One is he wants, the state quoted full and equal opportunity. He wants a full opportunity he wants to be able to do the thing, to congregate with fellow members of his religion, scheduled time and space.
But just to be clear, it's a 20-odd page complaint.
Yes, it's
You're saying it's really only
the
at the very
relief
end.
section. It's the section where he's stating what relief he wants.
Perfectly, right.
And the state has quoted and given you record sites for provisions in the grievances that relate to discrimination. Tucker wanted equal treatment. In other words, he wanted to be put out of Muslim services, which is where he was getting harassed. And he's now in Muslim services. So all the equal treatment discussion deals with that. And the fact that there are discussions of wanting equal treatment doesn't preclude this court recognizing what he wants, which is this congregation. I also think it's worth...
I'm sorry, but just to be clear then, it's paragraph 71, sub 4, provisions of scheduled time and venue for assembly and practice.
That's correct. And you can follow it through the briefing. It has always been about separate congregation. The state has conceded, this is important to voluntary cessation, he has conceded he would not win on the merits, which under the voluntary cessation test is relevant under the 3rd factor of Fenves and Texas v. Biden. So we meet all of the tests, all of the factors for voluntary cessation, and he would not win on the merits means that the state is conceding that it does not view Mr. Tucker as entitled to relief under RLUIPA. And that's exactly why this case is not moot.
All right, thank you, counsel.
Thank you, Your Honors.
The court will take this matter under advisement.